worked to design its products in ways that would capitalize on aspects of youth psychology that renders teens predisposed to impulse, peer pressure, and potentially harmful, risky behavior. Then Meta used the latest in brain science to ensure their products were stickier and riskier for our kids instead of using that knowledge to make products safer. And it's not just Meta, I use that as an example. Although the lawsuit from the attorneys general has resulted in ample Meta specific data points, we know that all major platforms operate with the same business goals in mind, and they are all part of the data capitalism, if you will, that informs these design decisions. And it's time that we do something about them. Folks might think that the risk of this is overblown, that resulting in addiction like symptoms for our kids might not be the issue recent media makes it out to be. If so, let me give you some examples. Something we learned as a result of the state attorney general's suit against Meta, this time in New Mexico, is the way in which Meta platforms connects children to pedophiles and child sexual abuse materials. This may seem like a content moderation issue, when in reality, data and design decisions are essential to the outcome of that issue. For Meta's recommendation algorithms and other design features, they have been shown to feed children's accounts to adult predators while also recommending private Facebook groups focused on inappropriate topics, child sexual abuse material, and more to accounts belonging to minors. It's important to remember that Meta's own research shows that they know when accounts belong to children. And they're actually explicitly working with advertisers under the promise of specific age audiences. Additionally, this lawsuit found that children are recommended these things not because it's the type of content that they are seeking out, but that Meta's products have profiled them based on their suspected ages. And what they've suggested is a flaw within their internal systems, then pushed these types of materials out to accounts matching these profiles. Let's be very clear. We would never allow a company to sell toys that contained anything even adjacent to child sexual abuse materials. We wouldn't allow walkie-talkies, for example, that automatically connected kids to adult strangers or adult predators. But yet when it comes to online products or services, we are expected to not regulate them against these harms. The age-appropriate design code model, Senate File 2810, comes from this model that is rooted in data privacy principles, requiring entities who meet size-specific standards, such as having annual gross revenue in excess of 25 million, with online services and products likely to be accessed by children and teens, to design their products to protect kids' privacy in an age-appropriate way. Like all of the physical things we have in this world, we are expecting to take that into the digital world. This means that data privacy impact assessments will be conducted and not necessarily collecting or selling children's data, setting high privacy standards by default and avoiding manipulative design practices. Senate File 2810 does not require companies to moderate content or prevent children and teens from searching for content they want to see. It does not prescribe how companies design or redesign features in the best interests of children. This gets upstream at the design phase for companies to take best interests of the children into account. By calling for safety by design and privacy by default, the Minnesota Kids Code serves as a path to accountability for tech companies. It simply requires tech to take a good, honest look at their products and then mitigate harm and exploitation of our children. Along with my co-author, Representative Bonner, I have spent this past several months working with stakeholders to ensure the version of the code we are discussing today is both feasible from an implementation standpoint and constitutionally sound. As a result, we have proposed several amendments to the Minnesota Kids Code that differ from the print in the bill. They don't have a substantive different on the back end, but they align with our court findings and previous precedent. We have provided you with the updated bill language as well as a summary of the amendments, but for the benefit of all, I will quickly summarize the key changes. It creates a duty of care based on best interests of children, defined as the use by a covered entity of the personal data of a child in ways that result in specified harms or discrimination, aligns the data protection impact assessments with the duty of care, and limits the data protection impact assessments to those products, services, or features that are new or currently offered to the public, creates a reasonableness standard within likely to access. Reasonableness is a legal term of art stemming from the common law of courts. It gives the court the authority to perform a reasonableness analysis based on an objective person standard. And it clarifies that there are no age assurance requirements. This was always true in the bill, but adding that clarifying language to quell any concerns. The Minnesota Kids Code does not mandate the use of document-based age verification methods or place other specific age assurance requirements on companies. In fact, it prohibits the collection of data not necessary to provide the service a child has requested. In other words, it will not age gate the internet. I have today technical experts and parents who will share with you why they are supportive of the Minnesota Kids Code. And with that, Madam Chair, I will stand for questions or let testifiers begin.
Thank you, Senator May-Quade. Representative Scott.
Recording in progress.
Thank you, Madam Chair. Don't have to flip switches in the House, at least not yet. Just wanted to ask what the intent is today with this bill, and there's a page and line amendment here that I hadn't seen until just now. After spending, well over an hour on the previous language last night. So what's
Thank you, Representative Scott, and I apologize. I meant to sort of frame things on the front end, and we just jumped in. I think our intention, we do have 2 additional meetings scheduled, one for the 22nd of January and one for February 6th. And sort of process-wise, what I assumed we would do is we would hear all the things that we wanted to hear, and then we would, on the 6th, maybe the latter part of that meeting, discuss the things that we've heard and whether or not we want to make recommendations, not make recommendations, et cetera. And that will give everyone a little bit of time to sort of, there's a lot of information, including the amendment that we just received yesterday, that will give all of us some time to digest that a bit. We are not required to take any action on anything, but I think primarily today we wanted to at least provide an opportunity to gather information.
Right. Thank you. I just want to put it on the record that, because there's a page and line amendment here and we haven't had really adequate time to review it, we're not going to be able to have a discussion today that is to this specific new language. And so to ask us to make a decision on February 6th, based on a discussion that we probably won't even have here today, the discussion that we should have had. I think it'll be more difficult to make that decision. And I would just hope that when the legislative session does begin, that whatever shape this bill is in, that it will have a full hearing and a full discussion and not just rely on the commission's recommendation, yes or no, but that we'll have a full vetted discussion with the full legislature, because I don't feel like we're going to be able to do it justice here today. I've been part of this commission since its inception, and I feel like this isn't the best way to do and vet bills for this commission. And I'll leave it at that, Madam Chair. Thank you.
And I thank you. And I assume that the business of the legislature will be to actually have hearings that will determine whether or not this is policy that we want to pass. We did want to provide an opportunity for stakeholders, both for and against the bill. I believe, as Senator May-Quade indicated, is the amendment that was provided to me yesterday also. That my understanding, and Senator May-Quade, maybe we'll direct this question to you, is that is something that you have worked on with stakeholders who had some concerns with the original language of the bill. Is that accurate?
Madam Chair, the language in here doesn't change any of the outcomes of the bill. It really is meant to put statutorily explanations that people felt were already in the bill, or that we know were already in the bill, but wanted to be really clear. That's a majority of this amendment.
Representative Scott.
Thank you, Madam Chair. Will somebody be going over the amendment line by line then, or are we just having the discussion and we're supposed to try to read the amendment while we're hearing testimony?
Was there an intention to go through this line by line? I don't know that there was, but.
Madam Chair, I'd be happy to go through it if you'd like.
Okay.
And whatever is your prerogative.
All right. If that would be helpful. Senator May-Quade, why don't you go through the amendment?
Thank you. If you have in front of you the amendment. So on page 2 after line 11, we are inserting age appropriate, a definition of age appropriate. It means a recognition of the distinct needs and diversities of children at different age ranges. In order to help support the design of online services, products, and features, a business should take into account the unique needs and diversities of different age ranges, including the following developmental stages: 0 to 5 years of age or pre-literate and early literacy, 6 to 9 years of age or core primary school years, 10 to 12 years of age or transition years, 13 to 15 years of age or early teens, and 16 to 17 years of age or approaching adulthood. Later on, we have best interest of children means the use by a business of the personal data of a child or the design of an online service, product, or feature in a way that, one, will not benefit the business to the detriment of a child, and will not result in reasonably foreseeable and material physical or financial harm to the child, reasonably foreseeable and severe psychological or emotional harm to the child, a highly offensive intrusion on the reasonable privacy expectations of the child, or discrimination against the child based upon race, color, religion, national origin, disability, sex, or sexual orientation. On line 230, we delete the word substantial. 2.31, delete effect and insert purpose. Page 3, line 1, delete and mitigate. Page 3, delete lines.
Senator McQuaid, can you hold on
Yes.
for 1 second? Yes,
I'm
Representative.
sorry, I don't want to be a thorn in the side here, but I wanted like an explanation of what the changes were, not, I can read, I don't need or Senator McQuaid to read it out loud. I just, I wanted an explanation of how the bill had changed, but, that's fine. We can take it up another time, but that was what I was kind of getting at rather than just reading the changes out loud. Thank you.
Senator McQuaid, are you able to offer some explanation for these?
Sure, Madam Chair, was there a request for a line-by-line read-through or for explanations of the changes?
I believe if I understand the request that Representative Scott would like you to provide an explanation of the changes.
Madam Chair, can someone bring me a copy of the OG bill, the original bill? I just have the amendment with me.
Senator Lucero.
Thank you, Madam Chair, and thank you to Representative Scott and to Senator McQuaid. I think I understand that the spirit of what Representative Scott is getting at, and because I concur. I very much appreciate this bill, this topic. It's a very important conversation that we need to have. But I'm similar. I spent several hours digesting and highlighting this language, and even if Senator McQuaid does go through and provide explanation, it's just not, I can't process it that quick. You know, individual words have meanings. So I'm just putting that forward. I concur with what I think the spirit of Representative Scott is getting at, in that I want to make sure this is an effective use of time also. So.
Right,
Anyway,
and I guess.
just putting that out there.
Sure, thank you. And in order to have this be an effective use of time, and just as a reminder, again, this is not the committee that will make the decision. We are here to provide a forum for information. We are here to provide the opportunity for stakeholders to come and provide information. I think that will be valuable. And once this moves forward in the legislature, there will be committee time that will be dedicated to and devoted to this sort of work. But this is, as I see it, committee work versus sort of what we are here to do today. So my understanding, I want to make sure that we are doing things that will be helpful. My understanding is that Representative Scott, you would like Senator McQuaid to provide at least some explanation perhaps on the larger parts of the amendment. And then my suggestion would be at that point, she can certainly take questions. We have a long list of people ready to testify to this bill. Senator McQuaid, I'm assuming some of the folks on the testimony list are individuals who are familiar with the amendment. Is that accurate? Okay. So I think that will be a process for us to follow today. And again, we can have a robust discussion today. We can have questions for all of the testifiers, including Senator McQuaid, and all of us will have an opportunity to review materials as well between now and February 6th. Senator McQuaid.
Thank you, Madam Chair. So I will go through and just talk about the pieces that you see in the amendment and kind of describe what it changes. I do want to be very clear, though, that the overall the point of the bill, the impact of the bill, the effect of the bill remains unchanged. These are, statutory clarifications, if you will, some to make clear what was already there in the bill but unsaid, and some that are just better definitions. Starting at the beginning, we've defined best interest of the child. This is something that exists throughout court precedent and is a legal definition that exists. We brought that into the bill. So I read that before. We've defined age appropriate, and then we've given both the range of years and what they're called, right? And this is important throughout childhood development. These are the ranges that exist within them. It's how a doctor or a psychologist or something might describe those ages. Under the dark pattern definition, down on page 2.30, we've deleted the word substantial to indicate that it has to be the purpose of misleading children versus simply a substantial effect of doing so. We made changes to the data protection impact assessment. So it realigns the assessment to focus on the online product, service, or feature with the duty to act in the best interests of children. It continues to require covered entities to develop a plan to ensure that all of the aforementioned things are designed and offered in a manner that are consistent with the best interests of the child who are reasonably likely to access the online product, service, or feature. And it requires the resulting plan to include a description of the steps of the covered entity has to take to comply with the duty to act in the best interests of children. Businesses must review and modify their data protection impact assessments as necessary to account for changes not biennially. And they have 5 days following the request of the Attorney General to service a list of all of the data protection impact assessments instead of 3 days. And then within 7 days, instead of 5 days, the entity must provide a requested data protection impact assessment to the AG. Attorney General will now have the discretion to extend beyond the 7-day timeline for providing a requested DPIA. We've added that the DPIA must assess whether the design of the online product, service, or feature could lead contacts on the online product, service, or feature that could result in, and then those are some of the things I read, material or physical or financial harm to the child, reasonably foreseeable and extreme psychological or emotional harm to the child, a highly offensive intrusion on the reasonable privacy expectations of the child, or discrimination on those protected classes. And it must do so weighing 6 design and data management practices, contacts, conduct, targeted advertising, data, and design features. Businesses that complete data protection impact assessments, and to avoid you listening to me butcher that over and over again, I'm just going to call them DPIAs, prior to releasing new online products, services, or features to the public, and are in substantial compliance with other obligations of the code. We have further clarified likely to be accessed by children and differentiates likely to be accessed by those under 13 to comply with the COPPA, and also adds reasonably to the likely to be accessed definition and provides a standard for actual or constructive knowledge. Entities are no longer required to enforce published terms, policies, or community standards. And then we articulate very clearly that nothing prevents children from affirmatively searching for the content that they want. Clarifies that covered entities must not use the personal data of any child in a way that the covered entity knows or has reason to know is inconsistent with the best interest of children. That is not that it is materially detrimental to the health or well-being of the child. So the same change that we made in dark patterns on 2.30 and 3.1.
Senator McQuaid, I do have a quick question.
Yeah.
So we do know that there was something at least similar passed in California, that there has been a temporary injunction. There has not been a determination of the merits on that particular piece of legislation in California. Can you describe how the version that you are putting forth and Representative Bonner are putting forth, how does it differ from the bill in California, and does it address any of the potential issues raised?
Thank you, Madam Chair. Yes and no. No, in that it still does the same thing that the California code does do, which is protect children's data in the online world. It was challenged through litigation. The district court granted the request for a preliminary injunction. However, they found that under the First Amendment, and because neither the California law nor the Minnesota law are seeking to moderate content online, instead of just asking platforms to take simple measures to conceal the data of the users, this feels like an overreaching interpretation of the First Amendment. So I disagree. We disagree with this interpretation, and I don't believe it'll withstand scrutiny as it moves up through the courts. It has been appealed to the Ninth Circuit, and so they'll be making a ruling on that. So I think the district court there is trying to, make privacy protections a thing that don't exist. But that's not really a thing. The freedom to speak is not to just like siphon data from unsuspecting internet users, particularly our children. That's not what the freedom of speech clause of the amendment or of the Constitution does. So the First Amendment is to preserve speech and expand, our ability to speak freely and not protect corporate power. Anyway, so the district court's decision is moving up to the Ninth Circuit Court of Appeals. I think that, big tech hates this bill. We've known that for a long time. They don't want to lose the profit margin and motivation to harvest data from children. They make a lot of money from it. And we can expect that when we try to protect our children and the bottom lines of big corporations are in the way of that, then we will expect to see lawsuits.
Representative Niska.
Thank you, Madam Chair, and Senator McQuaid. I just want to try to make sure that I'm heard the answer to that question correctly, because I think this is really important as we, are starting a new legislative session where 3 of the bills that were passed in the last legislative session are already subjects of preliminary injunctions in federal court. I want to make sure we're not going down the same road. And so I just want to make sure that I heard the answer to that question correctly. And I think what the question was getting at was if there's some distinction between this bill and the California bill that would matter for a similar challenge that was brought in federal court. And I think I heard the answer was that there's not, and that it's that your position is just that the California court got it wrong. So is there some difference that between this bill and the California bill that would matter for the purposes of a similar challenge to this bill?
Senator McQuaid.
Thank you, Madam Chair and Representative Niska. Yes, the big difference is that this bill does not moderate speech in any way, shape, or form. So it is not in violation of the First Amendment. It requires tech companies, like we require toy making companies, to have reasonable, simple, safe ways that they design products that children use. That is not in any way related to the First Amendment. And that is what would make this different from what the California court said.
Representative Niska.
Thank you. I appreciate that. Can you help me to understand what is it about the California bill that does regulate speech that this bill doesn't regulate speech? Because in the first answer you said these two, the bills do the same thing. And so I understand the argument that maybe neither of the bills, in your opinion, regulate speech. The court in California found differently. And so I just want to make sure that we're not just going down the same path that's going to be subject to the same type of legal arguments that in the California case on the side of the state government lost in federal court. And I'm not as confident as you are, frankly, that will be reversed when it goes up on appeal.
Senator McQuaid.
Thank you, Madam Chair and Representative Niska. I mean, what I can tell you is that, the legislature's job is to make the laws, and it's the judicial branch's job to interpret the laws. And so I think our best job is to make sure that we are passing the best legislation that we possibly can to protect our children. I'm very confident that this would withstand First Amendment challenges in Minnesota court, in federal court, in front of the Eighth Circuit, in front of the Supreme Court. And I think we should continue moving legislation forward that makes sure it protects our kids in the digital world like we have done in the physical world.
Senator Lucero.
Thank you, Madam Chair, and thank you, Senator McQuaid, for the rundown through the amendment. So I think as I'm mulling over here, most of my comments were going to be, your remarks were going to be to the original language. And I think what I'd like to do is just put a few of those out there, not that I'm looking for any answers, but before the testifiers come out so that they maybe can address some of these. And some of my questions might have been answered in here as I look at this later. But among the thoughts that I had, let me move my big hunking laptop out of the way so I don't have to contort myself to get to the microphone. All right. Some of the questions I was mulling over are in some of the definitions, it had a well-being of a child, and then it had a harm to a child on multiple places. And I'm just thinking to myself, who is the arbiter to determine what well-being is and what harm is, and then what will be the how to measure that. Another question I had as I was reading through this is the definition of personal data. Rather than reinvent the wheel, and it may or may not be applicable, and it may have been addressed in this amendment, would be to try to reuse the definition, the well-established definition of PII when it comes to gathering personal information that individually identifies people, perhaps rather than coming up with a new definition, using an existing definition, again, of PII. Then I know it's somewhere in here, and I can't recall exactly where it is, but there was to anonymize that the equivalent of PII, and then it had language in there that I wasn't super comfortable with that I think could be stronger to ensure, I think the word reasonable was there, to ensure that it could not be reversed. So if it had been anonymized, to reverse that back to being able to personally identify. So I think that was a conversation. Then I'm seeing here that when it comes to precise geolocation, it came down to 1,850 feet, the radius of 1,850 feet. And I did the math, and that's 0.35 of a mile. To me, I'm thinking from a real estate perspective, with my real estate hat on, a quarter-acre lot, 0.35 of a mile isn't a lot. In my opinion, to not be precise, it should be a much larger radius. But again, maybe some of the testifiers could speak to that, and that's a further conversation as Senator Makewaid and I maybe could have going forward. Continuing on, there were a handful of others, but here it is on bottom of page 5. It speaks to the personal health information. And I just wanted to get some more background. So maybe that's coming up in the testimony. Why is this in here? And should the Minnesota, is it the Records Act, Health Records Act, should that also be maybe considered as some language in here? So again, what's the background of the language on the bottom of the original page 5? So anyway, those are just a handful of questions and thoughts that I had as I was digesting. So thank you, Madam Chair.
Senator Makewaid, if you have a response to any of that, that would be great. And otherwise, we as testifiers are coming up, make note and we'll get some additional information.
Thank you, Madam Chair, and thank you, Senator Lucero. I appreciate your thoughtfulness and your expertise around this issue and your support for what we're trying to do with this bill. Best interest of the child is a legal definition that does exist and is used in court determinations all the time, particularly family court, if you're having, say, a custody discussion or a placement discussion. So it's something courts are familiar with, and that's why we've relied on something that they have a lot of experience using. I appreciate the PII point for definition, and I'm gonna look at that because I appreciate that. And then adding in the Minnesota Health Records Act, I'm going to guess, but I want to be sure, is that everything that's covered in the Minnesota Health Records Act is covered in the pieces that we have named in here with the federal laws. But I'm going to check and make sure, and it couldn't hurt to be redundant. Thank you.
All right. Thank you, Senator Makewaid. Oh, I'm sorry, Representative Scott. We made eye contact, but I didn't see a hand, so I apologize for missing the signal.
Thank you, Madam Chair. To dovetail with Representative Lucero's comments, the Minnesota Health Records Act is a stronger protection than HIPAA. So it'd be very important if we're really trying to protect the health data of these kids, then that trumps HIPAA every time. I also had some concerns, and again, I do want to reiterate too what's been said here. This is really important work. We want to make sure that this bill does what it says it's going to do. And my question is, what recourse do parents have if they find that this is any of these, any of the items in this bill have been violated? My initial reading of the other bill was that there's no private right of action. how can parents seek recourse?
Senator Make-Wade.
Thank you, Madam Chair. And Representative Scott, that is a really, really good question. I think the way that I would answer it, because I have a daughter, she's 20, I didn't have a daughter when we served together, but I have one now. And it's something I think about a lot. I would want to be able to personally go after these companies. I think one of the problems that has happened over time is that individual parents have been tasked with keeping their children safe online, while big tech designs features and products and tools that are deliberately keeping our children safe, unsafe online. And so what we have now is all these suggestions for individual parents, like it's your fault if your children aren't being kept safe online. You can do something, it's on you, when really it's on the companies, because the companies are designing these products and features and algorithms and apps to be deliberately unsafe with our children. And so at this point, it's not on any individual parent. It is on us as the governing bodies of the state and on the companies to make the changes, because no child is safe online the way that tech has created their products. And so there isn't a private right of action. There's hefty fines that the Attorney General can levy. It's $2,500 per affected child for each negligent violation. It's a civil penalty, but that was the reason, is that we didn't want it to keep putting that burden on individual families to find out that this happened and then try to subpoena, records from a large corporation to try to prove in a court of law that this one thing hurt my kid in this specific way. We already have that information that it's hurting all the kids who are using it. And we want to make sure that companies are held accountable for not designing products any longer that can hurt our kids.
Representative Scott.
Thank you. Thank you, Madam Chair. And I don't necessarily disagree with anything that you said, but is there, a friend of mine was saying recently that over the holidays, they were trying to look up a recipe for a cocktail online. There is a gatekeeper, right? You have to prove that you are a certain age to even get the recipe, right? You have to prove that you're eligible to consume alcohol. So why can't we have something on the front end of some of this that says there's got to be a way? There's got to be a way of gatekeeping this on the front end, because the damage has been done on the back end, which is what this bill kind of does. The fines don't even go to the parents or anything. It goes into the special fund here. And I just think just my 2 cents, and I'll listen to all the testimony and everything, but I want something on the front end. The average age, folks, of a child's first exposure to a pornography online is age 8. And it's not because the child is necessarily searching for that. It's because it pops up because of an algorithm. That's what I want to avoid. And there's got to be a way. That's all I could say. There's got to be a way.
Senator
Thank
Make-Wade.
Madam Chair, and thank you, Representative Scott, that this actually is that way. The difference between the cocktail recipe that you're talking about and the algorithm that will show children, sexually explicit images way before they should be seeing them, is that the cocktail recipe, you're verifying your age or lack thereof when you're going to see something, versus all of the, let's say your search engine is Google, right? It is harvesting millions of points of data about everything you search, everything you click on, how long you look on it for, where you like to go vacation, where you're thinking about maybe going to vacation, what kind of shoes you buy, what kind of chairs and furniture you buy, where you live, what the weather's like. All of that is just constantly being siphoned and siphoned and siphoned. And then the products are designed to either sell all that data to other people so that they can show you bad things, or they're using that to continually refine their products so that they can continue to show you things. And what we now know from some of these litigation pieces is that companies are using that information that they're getting to design products that specifically connect young people to harmful content. And so that thing that you mentioned at the end, the algorithm that's showing the 8-year-old the pornographic images, this bill is designed to get in front of that algorithm, to require companies to take best interests of the child into account if a child is reasonably likely to access what they're designing when they design it. And so it's not just for what we have now, but it's for all the things to come. Think about how far AI has come since we left last legislative session. Think about what all the tech that will be designed in the future. This bill is a forever bill to require all tech, whatever they may be, to take best interests of the children into account when they're designing a product that will reasonably be used by them.
All right. I think we should move on to testimony. I think we've covered everyone's questions. So the first person on our list is Casey Mock from the Center for Human Technology. Why don't you go ahead and identify yourself for the record and go ahead.
Thank you, Madam Chair, members of the commission for having me today. My name is Casey Mock, and I'm here in support of the Minnesota Kids Code. I'm the Chief Policy and Public Affairs Officer at the Center for Humane Technology, the nonprofit behind the award-winning Netflix documentary, The Social Dilemma. I'm also a lecturing fellow in science and technology policy at Duke University School of Law. I'm also a former lobbyist for Amazon and a former appointee of Phil Scott, the Republican governor of Vermont, where I led a state economic development agency and worked closely with the tech startup community in the state. Finally, I'm a resident of Seward in Minneapolis, and while I'm not a parent, I am an uncle to two tiny constituents of Senator Limmer in Maple Grove, 5 and 2 years old, respectively. So I'd like to use my remaining time here today with you all in the hopes that you'll remember one thing, a number, the number 270. That number comes from an internal Meta email released just a few weeks ago in the state attorney's general lawsuit against the company, which I'm going to read you a direct quote from. And I quote, "The lifetime value of a 13-year-old teen is roughly $270 per teen. This number is core to making decisions about the business, and you do not want to spend more than the lifetime value of the user." Let that sink in. None of these companies will take action to protect your kids if it will reduce that lifetime value, nor will they spend more than that value on protecting your children online than what they are worth to them. Your kid's worth to Meta is $270. Why is that relevant to this bill? It's not a business decision for an architect whether to include in her design for a skyscraper a fire escape. The building code requires it, and at this point, it's common sense. What this bill will do in a way that is light touch, platform neutral, future-proof, and content neutral without requiring any further data collection on children is change the incentives so that kids' safety is no longer only a business decision. It's as simple as that. Move fast and break things might be these companies' mottos, but no Minnesotan parents that I know would allow a babysitter into their home with that motto for childcare. It's time that Minnesota deliver the message to these companies that pay very little into our state to begin with, that our kids' health and safety is not for sale and certainly not at the price of $270 per child. Thank you, and I'm happy to take any questions that you all may have on the substance of the bill, why you're hearing what you're hearing from the tech industry on it, and the impact of the bill on innovation policy as well. Thank you.
Thank you. Any questions for? All right. Thank you today for your testimony. Next, we have Dahlia Hashad, Parents Together. And if you can just state your name for the record, and I apologize in advance if I pronounced it incorrectly.
You were perfect. Dahlia Hashad with Parents Together. Good afternoon, Chair Westland and esteemed members of the commission. Thank you for granting me this opportunity to speak before you today. As I said, I'm Dahlia Hashad with Parents Together. And in front of you, you should have a letter currently signed by 214 parents across Minnesota in strong support of the Minnesota Kids Code, along with individual comments. I'm here, quite frankly, because parents need help. For years, parents have been trying to work with social media companies, literally begging them for minimal protections to keep our kids safe. And these companies do nothing. They keep trying to make this an issue of parental responsibility. And when you think about that, and when you hear that, and you will, I want you to think of these 3 moms that I brought with me into the room and their children. The first mom here, right here, that's Annie McGrath. On Valentine's Day in 2018, her beautiful, precious son, Griffin, found the choking challenge on social media. He tried it and he didn't survive. In her grief, she started warning anybody who would listen, other parents, and begging the social media companies to take down these dangerous challenges. And they did nothing. This mom here, the second mom, Joanne Bogard. In May 2019, that same tragedy visited her when her beautiful son, Mason, who was 15 years old at the time, was served the choking challenge on social media through the algorithm. He tried it and he didn't survive. She had a great relationship with her son. She put software monitoring devices on software monitors on all of his devices. And she even talked to him about the choking challenge. She did everything right. And that's what we parents are facing. You can do everything right and you still lose because these products are not designed for safety. And since then, these two moms go online every single week and they re-traumatize themselves searching for the social media challenges, these deadly challenges, and they report them to the tech companies. And the tech companies refuse to take them down because they say they don't violate terms of service. I myself sat in a room with moms who lost their children because of the deadly choking challenge and tech executives. And they told the tech executives, we've searched this morning and we still found these deadly challenges online. And the tech executives did nothing. 7 months from the date of that meeting, this mom here, Tywana Anderson, she lost her 10-year-old daughter, Nyla, because Nyla was served on her For You page on TikTok a choking challenge. She tried it and didn't survive. She buried her daughter at Christmas. Since all of this has happened to these moms, nothing has changed and more children have been hurt. Today, someone who was supposed to be testifying in front of you today, Christy Wagner from Hutchinson, she could not be here to tell you about how social media algorithms have fueled her daughter's disordered eating, anxiety, and depression because she had to take her daughter and admit her again to the hospital for treatment. And she says in a written testimony that she sent to you today, the fact that I can't even be here with you today should tell you everything you need to know about how social media is destroying children and devastating families. If you take away one thing, please take away this. Parents are alone. We're outmatched and we're completely underwater. We can't keep our kids safe on social media. We can't because it's not within our control. It's within the control of these tech companies that design, create, and profit from these products. For years, parents have been begging. For years, parents have been pleading. And for years, parents have been denied. Tech companies refuse to make their products safe for children because putting our kids at risk makes them billions. Every industry that puts a product in front of our kids, whether it's a car seat or a football, they are required by the law to design those products so that they are reasonably safe for children. But when it comes to the social media platforms that virtually all of our children are on every single day, there's almost no meaningful regulation. And that means that no matter what we do, we can't keep our kids safe on these platforms. And just to wrap up, I just want you to consider two facts. Research found that within little more than 2.5 minutes, TikTok recommended suicide content to a teen account. For a child to log off Instagram, it takes 5 clicks, but they can connect with a drug dealer in 2. It's an impossible task for parents to be required to keep our kids safe on these platforms, all of them, when there are no laws requiring the safety we need. Tech companies have proven that they will not do it on their own. They will not do it voluntarily. We need the law to step in. And we are asking you, parents everywhere are begging you, please. support the kids code to give the families the regulation we need and that our kids really deserve.
Thank you so much for your testimony. Any questions for Ms. Hashad? Thank you so much
Thank
for
you.
sharing that information with us today. Appreciate that. Up next, we have Eric Mishi. We'll see how I did on your name. Thank you. Please identify yourself and when you take a seat, and you may go ahead.
Good afternoon. My name is Eric Mishi. I'm the Executive Director of SAVE, Suicide Awareness Voices of Education, which is a Minnesota-based suicide prevention nonprofit that operates throughout the entire country. Chair Westland, rest of the committee, for 34 years, SAVE has been working to prevent suicide through raising public awareness, training, and educating individuals and community stakeholders, and serving as a resource for suicide loss survivors. Suicide is a preventable public health problem, but sadly, each year suicide rates continue to rise in Minnesota and across the country. We lost 835 people by suicide in 2022 here in Minnesota. For our youth ages 10 to 24, suicide is the second leading cause of death. Research consistently shows a strong link between suicide and depression. Research also shows that adolescents who spend more than 3 hours a day online double their risk of experiencing poor mental health outcomes, including symptoms of depression and anxiety. Yet we also know that social connections help us live longer, more robust, and happier lives. The Minnesota Age-Appropriate Design Act is essential. It provides a reasonable, tested, and practical framework for improving the digital spaces where young people spend more and more of their time. I want to emphasize that this act won't shut kids out of online spaces or limit their access to information. On the contrary, the bill will simply hold technology companies accountable for their products' reasonable and foreseeable outcomes. I want to emphasize that. Hold them accountable for their products' reasonable and foreseeable outcomes. It simply mandates that their online platforms act responsibly with youth data and mitigate against specific harms and discrimination. For SAVE, the emphasis on preventing discriminatory outcomes is significant, as we know that LGBTQ plus youth who come from families that reject or do not accept them are over 8 times more likely to attempt suicide than those whose families accept them for who they are. African American, Latino, Native American, and Asian American youth who are lesbian, gay, or bisexual attempt suicide at especially high rates. We also know that bullying, harassment, and targeting of young people based on their age, their gender, their sexual preference, their body type, and a host of other factors is not only real, it is devastating, and it is preventable. As both the research and our firsthand experience show, young people must have guardrails in place to protect their mental health, especially online, where they are often alone with no other perspective than the one presented to them there. It is not hyperbole to the families who have lost children to suicide to say that lives are at stake if we do not require companies to design their products and services in a privacy protective manner with the safety of children in mind. And it is most certainly not fair to say that parents should bear the burden or the sole responsibility to protect their children. Parents' rules and limits are no match for companies who deliberately design their products to manipulate children's developing brains into craving more and more time online. Ratings, warning labels, content moderation may be good public relations, but does not address the core issue, which is companies creating products that target young people and endanger young people through their design. This act will incentivize the responsible and ethical design of online spaces that we have already seen can be used innovatively to promote healthy online habits and relationships rather than exploiting the data of our most vulnerable youth. On behalf of SAVE, we ask this commission to consider the passage of this bill in the upcoming legislative things. Thank you.
Thank you. Any questions for Mr. Mishi? I just would like to personally thank you for your organization. As some of my colleagues may know, my best friend died by suicide in 1991, and that is when I first became aware of your organization and the incredible work that you do, and I just wanted to thank you while you were here.
Well, thank you. It's a privilege for us to be able to do this. Thank you. Thanks.
Next up, we have Andy Kingman, State Privacy and Security Coalition. Once you get settled, if you want to just identify yourself for the record, and then you can go
I'm
ahead.
sorry?
Just identify yourself for the record and go ahead.
Yeah, absolutely. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. Thank you, Madam Chair. SPSC is a multi-sector coalition representing over 30 companies and 6 trade associations. I also have a background as a privacy compliance attorney helping companies work through various privacy laws across the country. Of course, children's safety is an extremely important topic. Our testimony today focuses on the First Amendment considerations and the unintended consequences of the AADC bill here. And I would qualify this by saying, obviously, there were a number of amendments released today. Still working through them. We'll probably need a little bit of time to understand their consequences. But having said that, you know, this isn't a case of business being on one side and everyone else on the other side. This is a case where many civil society groups have joined to express their concerns about the unintended consequences of this law. In particular, the idea of restricting content to particularly vulnerable populations in their youth, as well as the increased data collection that will necessarily result from the implementation of this law. The Electronic Frontier Foundation wrote a veto request to Governor Newsom. There was an LGBTQ group that filed an amicus brief in support of the plaintiffs in the California action. And the Center for Democracy and Technology sent a letter to federal lawmakers around the Kids Online Safety Act, which contains many of the same sort of goals, language provisions. And they said that that act establishes a burdensome, vague duty of care to prevent harms to minors for a broad range of online services reasonably likely to be used by a person under the age of 17. And while the aims are laudable, it is effectively an instruction to employ broad content filtering to limit minors' access to certain online content, and that it is notoriously imprecise. It is curtailed access to critical information such as sex education or resources for LGBTQ plus youth, and that online services would face substantial pressure to over-moderate. This letter was signed by the ACLU, by GLAAD, by the Human Trafficking Prevention Project, and I think 87 other civil society groups. So again, this is not something where there are clear divisions about you know, where different interests may fall here. I think the biggest concern that arose and that was validated by the preliminary injunction that's been issued in this case is the increased data collection that would result, again, necessarily. At its core, this law is about the government being able to tell companies to not offer, or that they're not able to offer some services or content, and that they are able to offer other content. And because the law applies to anybody who is likely to anybody under 18 who is likely to access any website, you know, companies will again necessarily be forced to increase dramatically their data collection to make sure that they're complying with this law. So how does that work? That could include things like providing driver's license information. That could include things like using biometric technology to estimate age. things along those lines that I think would be more invasive. And that's a significant amount of concern, significant concern for industry. I will just quote from the preliminary injunction. There was some conversation earlier wondering what, asserting that this isn't protected speech. I think the court was fairly clear. Whether there is a general right to collect data is independent from the question of whether a law restricting the collection and sale of data regulates conduct or speech. Under the Sorrell case, which is US Supreme Court precedent, the unequivocal answer to the latter question is that a law like the AADC restricts the availability and use of information by some speakers and not others, and for some purposes but not others, is a regulation of protected expression. So I'll pause there. But again, our concerns are the First Amendment issues that the court in the Northern District of California looked at, as well as the increased data collection of youth.
Thank you. I do have a couple of questions.
Sure.
And I understand you're still working through the amendment, and so there may be some measures in there that address your concerns. I guess my first question is, have you had contact with the Senate and House bill authors and been able to identify specific language in the bill that does the things that you're saying that it does? And have you proposed any changes or modifications that would address the concerns that you're raising?
Yeah, so I think, what's difficult is that the court analyzed in California all 10 provisions of the AADC and found that not only were all 10 of them unconstitutional, but that law had a severability clause saying, well, if something over here is found unconstitutional, then something over here would still survive. They said that they were so intertwined that it would be impossible to sever them. So I think the question is, what's the right approach here? I think we want to be constructive, hoping to meet with the sponsor tomorrow at the NCSL conference on children's privacy. I think, we're working with Representative Elkins and as the comprehensive privacy bill starts to move forward. I think that is much more about data protection than content moderation. I think this isn't necessarily a data protection bill per se. I think this is more about content moderation and product design. So we do want to be constructive partners. I think it is an important issue. It is a very, very difficult needle to thread when you start talking about restricting content or judging what might be materially detrimental or harmful to one child over another.
My understanding of the case in California, the procedural posture to that is that it is currently on appeal, that there is a temporary injunction. I don't think that there has been a final determination on the merits of the case. Is that accurate?
That is correct, although I would point out that one of the criteria for a preliminary injunction is a likelihood of success on the merits. Also, while most First Amendment cases are usually analyzed using strict scrutiny, which is obviously the highest level of scrutiny, the judge in this case analyzed this under intermediate scrutiny, which is a lower level scrutiny, and found that it would still have a likelihood of being found unconstitutional on all 10 counts.
Okay. And it is my understanding also that last session, a study has been commissioned on this bill. And I believe there is a study due or a report from that task force on February 1st. Are you aware of that study as well?
Yes, and I'm not sure what I haven't been involved in the study formation, so we'll see where that goes. And I don't know whether the injunction has affected that at all.
Okay. Any other members have questions? Senator Limmer.
Thank you, Madam Chair. One of the questions I did have is your discussion about protected speech. You made reference to Supreme Court decisions, but part of the discussion we have today in light of the bill is the targeting the targeted marketing of information directed at inappropriate audiences based on algorithms. I understand the concept of protected speech, but is there a protection that the Supreme Court has created to target specific messages to inappropriate audiences as a constitutional right?
So
Mr. Mishi, or sorry. Go ahead.
the court, no, I will follow up with more detail. I believe the Sorrell case that I just spoke of was specifically around targeted advertising and whether that was protected speech. And I don't want to provide incorrect information, so I will follow up. The other point that I will say is that if that is the sort of primary concern or thrust here, the comprehensive privacy bills in other states have provided opt-in consent requirements for children to receive targeted advertising. So they'd have to affirmatively say yes, or their parent would be able to affirmatively opt in. So there is that level of protection in some of the comprehensive privacy bills, and that's something we'd be more than happy to talk about and work with Representative Elkins on.
Madam Chair, we heard testimony, I believe, from parents or parent representatives that despite their best efforts, some of this messaging still gets in front of kids. And I'm not quite sure how you stop that from a technical perspective. And that, Madam Chair, will probably require another committee to analyze, but it's true that in your comments that this commission focuses mainly on data practices. However, you really can't separate the data practice from the venue that we have in front of us. And we've had a lot of discussion about how do you regulate the internet when it's an international entity. And states around the country are trying to get a handle on what's pouring into their state and certain audiences that a lot of constituents think are inappropriate for the messages. So I don't know if this requires federal action, but I'm sympathetic to states that want to control the messages and some of the real sordid messages that come into everyone's homes, whether we like it or not. Every once in a while, something pops onto a screen that your eyes start to burn a little bit. And to think that young kids are subject to it as well, compared to parents that can't, due to their best efforts, stop it, is a concern. So I want to thank the chairwoman today for bringing this subject forward in our committee. It will take a couple more hearings to really go through this. And I think Representative Scott brought up the subject that this is a lot of stuff to swallow right now. And I'm looking forward to a few more detailed questions in the future. Thank
Certainly.
you.
The Judiciary Committee is a deliberative body,
Ooh.
and we look forward to that. Mr. Kingman, any other questions for Mr. Kingman? Okay, thank you for your time. Oh, actually, I do have one question. Do you have a citation for the Sorrell case?
Yes, I do. It's actually in my testimony.
Oh, okay, great. I will look it up. Thank you.
Thank you.
All right, Tyler Dyers from TechNet. Please state your name for the record and then go ahead.
Good afternoon, Chairperson Westland and members of the commission. My name is Tyler Deers. I serve as the Midwest Executive Director for TechNet. We are a technology trade association. We represent approximately over 90 innovative member companies. TechNet and our member companies strongly believe children deserve a heightened level of security and privacy online, and there are several efforts within the industry to incorporate protective design features into websites and platforms. Our member companies have been at the forefront of raising the standard for teen safety and privacy across our industry by creating new features, settings, parental tools, and protections that are age appropriate and tailored to the differing developmental needs of young people. However, I am here before you today in opposition to Senate File 2810 because of the breadth of this legislation would be felt by many businesses that operate on the internet. There are some legitimate privacy concerns as well that persist in the bill, as well as the constitutionality of the California Age-Appropriate Design Code, which is being currently litigated, as was mentioned, with a preliminary injunction in place based on provisions that are also contained in this legislation. The Minnesota AADC, while well-intentioned, is a major piece of online internet regulation that has many unintended consequences that would be felt by internet platforms, both large and small, and much broader than big tech. It would apply to websites that are likely accessed by a child under the age of 18, as opposed to the current nationwide framework under the Children's Online Privacy Protection Act, or COPPA, which does not use a likely to be accessed standard. Rather, COPPA uses a directed at children standard, with a child meaning an individual under the age of 13. Minnesota is therefore proposing an expansive scope far beyond what is covered under federal law. The phrase likely to be accessed creates considerable uncertainty, particularly when a child includes all individuals under the age of 18. Furthermore, the bill would require any website that is likely to be accessed by a child to have the best interest of the child in mind, and we need to complete a data protection impact assessment for any online service, product, or feature on the website that is likely to be accessed by a child. These impact assessments would require companies to determine whether the design of the online product, service, or feature could be harmful to children. Yet the bill is silent on who determines the best interest of the child and what is harmful. That being said, it seems difficult to put in statute what could be harmful to any child in any definitive way that would be actionable by companies attempting to comply with the law or regulators who are tasked with enforcing it. This new regulatory regime would apply to any business that has a personal information on 50,000 consumers and operates an online service that, again, is likely to be accessed by a child. That could be 50,000 emails, 50,000 account usernames, any data point with personal information consisting of 50,000 or more would be captured under this bill. A business, for example, would be expected to document the potential harmful risk to children, for example, photographs and videos depicting the global effects of climate change, images of war, or cooking a video showing how to grill a hamburger because the video involves a fire or use of a stove. A valid question raised in the California lawsuit is how can a website verify that you are indeed under the age of 18? According to the text, websites would need to estimate the age of child users with a reasonable level of certainty. But the bill does not specify how a website or platform is supposed to conduct such a requirement, because every available option is problematic in ways that undercut the objective of increasing children's privacy. There are three main ways that a business could achieve age estimation. You have self-reporting, also called age gating. This asks users to report their age or check a box certifying their status as an adult. Self-reporting is not considered a reliable method of determining age because of the user's ability and incentive to misreport. As a result, it probably does not satisfy the bill's requirement that a business estimate users' age with a reasonable level of certainty. The other, as was mentioned in the previous testimony, is document review, which we are seeing states in Arkansas and Louisiana attempt to do. This involves users submitting documents showing their age, again, to access content or expression online. This could be a government-issued form of identification, such as a driver's license or a passport. This process also has numerous limitations, including the cost and time required to review the submitted documents, and the fact that many people, both children and adults, may not have government-issued documents confirming their age. And then the last one is automated estimation or facial recognition. This obviously carries its own privacy risks, nor would Minnesotans welcome having to scan their face to prove their age when they're viewing their favorite websites. And this would apply to everybody that visits a website, because how would a website know how old you are with a reasonable level of certainty unless you verify your age through these mechanisms? Now, the bill goes on to say that if a website cannot estimate the age of a user with a reasonable level of certainty, then they could forego age estimation and provide these child controls to all users of the internet, which would fundamentally change internet as we know it today. The Minnesota AADC also fails to recognize the potential for over-collection of data to identify its users without any data protection standard in place. Currently, Minnesota does not have a comprehensive law that governs the collection of this new data under mandate under the bill. In other words, companies would be undoubtedly collecting more data without any data protection law to protect consumers. TechNet was working with the authors of the consumer data privacy legislation with a goal of reaching an agreement on the bill hopefully this session. We believe it's an important foundation for any other bills dealing with data privacy or technology. Again, we believe that protecting everyone's privacy will protect children's privacy. Similarly, we would also welcome the opportunity to meet with the authors of the AADC as well too. In the interest of time, won't go into the legal issues, but I'll conclude my testimony and happy to answer any questions.
So I do have a quick question, same question I asked the last testifier. Have you had an opportunity to look at the amendment? And and if so, does that address any of the concerns that you're raising?
Madam Chair, I saw the amendment this morning, probably about 2 hours before, so I didn't have enough time to go through it. Also for our membership to vet the amendment as well. So I don't have a solid answer for you yet.
Okay, that's great. Senator Lucero?
Thank you, Madam Chair, and to the testifier. Can you point me under the original language? You just concluded the testimony with concerns about additional data collection without data protection. Can you just point to me in that bill as I go back then and compare this with the amendment? What specific language are you referring to in the original bill? If you could just point, where is that additional data being collected?
Yes. Madam Chair.
Mr. Deers, go ahead.
Madam Chair, Senator Lucero. So page 6, line 28, it says that the platform must estimate the age of a child user with a reasonable level of certainty. And so in order to accomplish that, you would have to have some sort of assurance that the individual who is accessing that website is indeed who they say they are at the age. And therefore, thus resulting in further data collection.
Anything else? Any other questions? Representative Scott.
I'm glad the testifier brought up the 50,000, the personal data of 50,000 or more consumers. And I guess this is really more a question to the bill's author. Is that 50,000 consumers in Minnesota? Is that 50,000 consumers globally?
Senator McQuaid.
Thank you, Madam Chair. Representative Scott, were you talking about,
5.21 of the original
Thank
bill,
you.
Madam Chair, Representative McQuaid, or excuse me, Senator McQuaid.
Representative Scott, oh, sorry.
Senator McQuaid.
Madam Chair, thank you, Representative Scott. It is someone who does business in Minnesota and a loaner in combination annually buys, receives for the business's commercial purposes, sells or shares for commercial purposes, the data of 50,000 or more consumers or households or devices. So that's, anybody. I will remind folks on the committee that the purpose of the age appropriate design code requires them to do age estimation that's appropriate to the risk of what they are doing with the data. So for example, if I operated a website where I sold Tupperware and people signed up and I sent them emails to say, hey, I'm selling Tupperware again on Saturday, check back. But I didn't do anything with the data of the people who are buying the Tupperware, I wouldn't need to do a risk assessment because there's nothing at risk with the data of the people who are signing into my Tupperware website. If, however, I took all of the data for people who signed into my Tupperware website and sold it off to a bunch of companies who are using the geolocation of all these Tupperware buyers who are then being targeted by, people who want to, exactly, right? Then I would have to do a different risk assessment. If I had a website that was selling toy walkie-talkies, and the walkie-talkies, had little geolocators in them so that you could talk to other kids who had little walkie-talkies like yours. And then I was selling the data of who had those walkie-talkies so that people could know who are the kids that have these little walkie-talkies with the geolocators. Really different risk assessment I'm going to have to do with that data. So I want to point you back to the line that the testifier just read off and read you the rest of it because it's very important that people see it. It's estimate the age of child users with a reasonable level of certainty appropriate to the risks that arise from the data management practices of the business or apply the privacy and data protections afforded to all children, to all consumers. So this is about the risk to children versus what they're doing with the data. If they're not doing anything risky with the data, then it doesn't really matter. But if they're doing risky things with the data, which I believe we know a lot of corporations are doing, and that is why they have a problem with it. They're doing risky things with the data. and they don't want to have to do the assessment and treat that data differently.
Representative Scott.
Thank you, Madam Chair. And thank you for that. The testifier also brought up, and this is something a question that I had in reading through this, is who is the arbiter? Who are these companies? Are they supposed to hire child psychologists to determine what's in the best interest of the child? And I know you had some cursory outline of age appropriateness and stuff, but whether it's them or the AG's office, how do they determine what is going to be detrimental to a child's physical or mental health?
Senator McQuaid.
Thank you, Madam Chair and Representative Scott. So I think one of the things that happens a lot, certainly from tech companies, they want to pretend like the internet is really complicated and that tech companies don't have all of the tools that they already have. Currently, tech companies can estimate within 6 months the age of their users. They don't have to collect any more data than they're already collecting to estimate the age of their users. And so the way that they try to make this confusing is that, they're gonna have to collect all of these things, they're gonna have to do all of these additional things. The best interest of the child, companies already know that, right? So the business objective that they have leads to the design choice. So for example, if the business objective is to, reach as many users as possible, then their design choice is to promote connections and network building. And then that means that they want kids to stay online more. And if they know, because they do this on research, we've known for a while, Meta has known for a while, that Instagram, for example, has led to a 33% increase in disordered eating and harmful body image stereotypes for young girls in particular. They know that, and yet they had to do nothing about their algorithm or the way that they design Instagram to show up on young people's feeds. And so the information is already there. This bill would just require them to use that knowledge to change what they are doing. Best interest of the child is laid out in the amendment. And so it's reasonably foreseeable and material, physical, or financial harm to a child, reasonably foreseeable and severe psychological or emotional harm to a child, highly offensive intrusion on the reasonable privacy expectations of the child, and then discrimination based on protected classes. So once a company knows that harm is happening, they would have to change that design. They often do. They do this research. They work with child psychologists and brain developers already to get children to spend more time on their platforms. They already do this work. It's us that have left them alone to just take the information and do nothing except make things worse.
Representative Scott.
Thank you, Madam Chair. And I know we have another bill to get to, and I don't want to belabor this, but so that brings me to a question. So if you're looking at a child's physical health, and I'm interested in the testifiers' take on this as well. Let's say they have the Chick-fil-A app and they just, they have resources, they go out and they eat Chick-fil-A in excess, which is not good for their physical health. Is the company responsible for that?
Who's that? Is that for Senator McQuaid? Okay, Senator McQuaid and then Mr. Deers.
Madam Chair and Representative Scott, so this is the difference between what is sometimes being put in front of you as that this is content moderation and that the choices that children are making are different than the algorithms and the products that are designed to lead them to unsafe choices. So it might not be good for their physical health to eat, Chick-fil-A 45 times a day, every day for 15 years, but it's not unhealthy to eat food, right? And so if we're looking at material physical harm, those are things like, pedophilia and predators being connected to your child versus, eating food. I don't think that's falls within the non-best interest of a child. And it really matters what Chick-fil-A is doing with the data from the app. It's not so much what the app is. Does that make sense? It's about what they're doing with the data and if it's risky, not if what they're doing in there could, lead to childhood obesity.
Mr. Deers, do you want to respond as well?
Yeah, Madam Chair, I don't know how the Chick-fil-A app and specifics are designed, but I think that's kind of what I was mentioning in my opening remarks, which was the kind of the unintended consequences of this and the potential breadth for not just big tech companies to fall, subject to this regulation.
Senator Lucero.
Thank you, Madam Chair. And Senator McQuaid brought up a point that sparked a something that I just want to throw out there as well as we consider this in the weeks and months going forward. So there was the illusion was social media and the imagery and messaging that they're bringing across and how that influences young women or teen girls with body image, et cetera, very, very much real. Then I'm thinking back in the 20 years ago in my cybersecurity career, how there was very well-established principles in the physical space, such as theft or crime, et cetera. Then those exact same activities were happening in the digital space, and somehow people just didn't connect the dots. How this behavior in the physical realm, even though it's taking place in the digital space, it's not new. It's just we have to apply similar well-established principles in the digital space. So as that was brought up, I'm thinking to myself, well, body imagery, television has already been around. So, and I do not know the answer to this, so I'm throwing it out there. Are there regulations in the space of marketing, whether it be magazines or television, that control the type of content and imagery that is put across because of the recognition of the truth that does have influence? I mean, that's what marketing is. It obviously influences people's decision and thought process. So maybe there's another area for us to look at in the digital space or in the, if you want to consider television, the physical space, but something that's more mature and it's come before social media that perhaps does have regulations and it has been vetted and there is good verbiage and language that could be then applied in this scenario. Anyway, just throwing that out there as, again, in the continued attempt to not reinvent the wheel, but take the wheel and just apply it to innovative technology. So thank you, Madam Chair.
Thank you, Senator Lucero. I think we will call up our next witness. Thank you for your time, Mr. Deers.
Thank you.
Amy Bose from Net Choice. And if you can just identify yourself for the record and then go ahead.
Good afternoon, members of the commission. My name is Amy Boss. I'm the Director of State and Federal Affairs at Net Choice. Net Choice is a trade association of leading internet businesses. Our mission is to make the internet safe for free enterprise and free expression. We share the sponsor's goal to better protect minors from harmful content online. Our members have taken issues of teen safety seriously and in recent years have rolled out numerous parental tools, settings, and protections to better empower parents and assist in monitoring their children's use of social media. Additionally, we agree that the mental health and well-being of children is a critical policy area that we need to tackle. I think especially in these past 3-4 years, children have been through a lot. It's not going to be solved through a single piece of legislation, but it needs to be a conversation we need to have. We do know that this law is unconstitutional, as we've seen in court decisions in California and in Arkansas. SF 2810 largely mirrors California's age-appropriate design legislation. In September, as has been noted, the United States District Court for the Northern District of California granted our motion for a preliminary injunction enjoining the enforcement of the legislation. The court, after reviewing 10 of the Act's provisions, held that all 10 likely violated the First Amendment. Minnesota's AADC is similarly likely to run afoul of the First Amendment due to its strong inducement for online platforms to over-censor content in order to avoid being penalized under the law's vague concepts such as harmful to minors or best interest of the child. Under threat of massive fines for misjudging what may be considered potentially harmful, many platforms will certainly default to taking down content on entire subjects, which is likely to remove beneficial, constitutionally protected material along with anything genuinely harmful. Make no mistake, we are talking about the government banning speech online. This is why the New York Times sided with Net Choice against the state of California's anti-speech law. Additionally, this bill is a de facto age assurance requirement. Age assurance and estimation will require more data collection, and children and adults alike will have to share with virtually every website visited some sensitive personal information like identification documents or face scans that, should they fall in the wrong hands, could be used for nefarious purposes. As Judge Freeman noted in granting the preliminary injunction, the law compromises privacy, writing that it is actually likely to exacerbate the problem by inducing covered businesses to require consumers, including children, to divulge additional personal information. Beyond its First Amendment violations, the legislation is unconstitutional under the Dormant Commerce Clause because it regulates behavior and activities that take place outside of Minnesota. The law imposes requirements on websites for the use of tracking and storage of information about users who are under the age of 18. These requirements conflict with COPPA, a federal law that governs how websites handles minors' data. Therefore, SF 2810 also violates the Constitution's Supremacy Clause. In conclusion, this legislation is well-intentioned but constitutionally flawed. The law is simply too vague for even the most conscientious online service to be able to comply with, and would thus likely pose unconstitutional burden on both platforms and users' rights to speech. Thus, we ask that legislators would oppose moving such legislation forward. Thank you again for the opportunity to testify, and happy to answer any questions.
Any questions? All right, thank you for your time today. Sarah Strong from the Minnesota Newspaper Association. Ms. Strong, if you can identify yourself and then go ahead with your testimony.
Thank you, Madam Chair and members. My name is Sarah Strong. I'm here on behalf of the Minnesota Newspaper Association. When the age-appropriate design code proposal was discussed last session, M&A requested an exemption for professional news organizations because subjecting them to a proposal aimed at social media and tech companies will provide no public benefit and is likely to have unintended negative consequences on their ability to deliver news to the public. We are very grateful to Senator Makewaid and Representative Bonner that an exemption was adopted as part of the bill late last session, and we appreciate their continued support for a professional journalism exemption as the bill moves this year. To be clear, Minnesota newspapers do not oppose the goal of the legislation, and they understand that the proposal is not aimed at them. Without a clear exemption, however, they would be impacted by it despite not being the focus. Some provisions introduce ambiguity that would make compliance difficult and could limit the ability of professional news organizations to provide valuable information to the public they serve. This could produce very adverse consequences, not only for the state's news media, but for our citizens and communities, but an exemption will avoid these unintended consequences. The A3 amendment maintains the journalism exemption, but also requires news media to submit an annual data protection impact assessment. We have not had time to assess that language, and so I can't speak to its impact or our position on it. What I can say is that if a requirement of any kind within this scope is placed on professional news organizations, it needs to be clear, reasonable, and provide a real public benefit. Even limiting the obligation to an annual assessment is not likely to be as simple as it may sound. This is a new and complex territory for even Minnesota's largest news publications. Professional journalism plays an important role in the democratic process and in supporting local communities. Millions of Minnesotans, including young readers, rely on the state's news organizations to stay up to date on the latest local, national, and international news and cultural and society happenings and much more. We look forward to continuing to work with the authors and all of you to ensure that Minnesota's news organizations will not be inhibited in performing this vital role. Thank you.
Thank you. Any questions for Ms. Strong? All right, thank you. Keep moving my paper. Jeff Kluge. And is he online? Oh, he's in person too. Jeff Kluge is up next. Thank you. And I apologize again if I've had done a hatchet job on your name. Please state your name for the record and then go ahead with your testimony.
Yes, Madam Chair, this is Jeff Kluge. You did a remarkable job on my name, and thank you for that. Good afternoon. I'm CEO and founder of Holistic Ethics, a Minnesota-based LLC, and the creator of Kids Tech Ethics. Contrary to what the opposition tells you, the Minnesota Age-Appropriate Design Code is genuinely pro-business. For over 25 years, I served founders and venture capitalists in Minnesota as a trusted financial advisor. I mentored senior executives, sitting alongside them, guiding product and business strategy. I learned firsthand that leading businesses excel in addressing their customers' existing problems and anticipating future needs. These businesses prioritize the understanding and fulfilling of the best interests of the customer. What we see today with Minnesota AADC is an extremely useful framework for businesses to conceptualize building artificially intelligent, algorithmic, and autonomous systems and online products and services that are directed towards children, designed to help rather than hurt consumers. Big tech opposes any regulation regardless of the approach. Big tech does not have Minnesota's interests in mind and surely does not have Minnesota children's best interest at heart. That is your job as elected officials. And the truth is that implementing the Minnesota ADC positions our state as a hub for innovation and for ethical business and technology practices. But adhering to AADC principles, businesses gain a competitive advantage, showcasing a commitment to user well-being, privacy, and responsible data processing. The approach aligns with evolving consumer expectations and sets a high standard for industry leaders. But as we've seen time and time again, in the case of AADC, big tech latches on to isolated micro issues without acknowledging the act's overall careful balance of flexibility and protection. Provisions like the requirement to consider age brackets, widely supported by child development experts, and implementation of DPIAs, precisely represent the kind of holistic solutions necessary for addressing the concerns raised by the industry. What opponents attempt to characterize as restrictions infringing on free speech are nothing more than a red herring. The AADC does not limit what businesses can say or display to children. Rather, it reasonably protects children's personal data in how it's collected and how it's processed behind the scenes. Companies remain free to curate any lawful content and offer services to children. However, they cannot exploit excessive data collection and opaque, unauthorized uses that enable dangerous targeting. Speech is not the concern. Unethical data practices are. Make no mistake, Minnesota has a compelling, urgent reason and interest in protecting children online. The AADC is a narrow, measured approach addressing demonstrated harms from platforms optimizing for youth engagement without regard for the child's well-being. Doing nothing poses serious risks to our kids' well-being, health, and safety. I urge you favorable recommendation on SF 2810. In the packet in front of you was a submission I had that outlined the 10 points of the Net Choice versus Bonta in California, giving a bit further detail and analysis. Happy to answer any other questions. Thank you.
Thank you, Mr. Kluge. Any questions for Mr. Kluge? All right, thank you so much for your time today. Now we are down to our last two testifiers, both of whom are joining us remotely. First will be Corey Marshall from the Chamber of Progress.
Hello. Good afternoon. Can you hear me?
Yes, thank you. Go ahead.
Good afternoon, Chairwoman, and to the distinguished members of the Commission. I'm Corey Marshall, Director of State and Local Public Policy for the Central Region at Chamber of Progress, a tech coalition promoting equitable access to technological advancements for all Americans. Today, I'm here to respectfully voice our opposition to SF 2810, which would undermine its own goals by sacrificing user privacy and jeopardizing many of the safe tools and resources already available to children. Our organization works to ensure that all Americans benefit from technological leaps. Our corporate partners include companies like Google, Amazon, but our partners do not have a vote or veto over our positions. SF 2018 would require covered sites to estimate the age of child users with a reasonable level of certainty. One of the only ways to estimate users' ages is with enough certainty is to avoid liability under the bill would be to affirmatively verify it. The de facto age verification requirement would likely result in covered entities extracting even more data about their users. In spite of this bill's stated emphasis on data minimization and privacy principles, there is There is disagreement about the best methods for verifying users' ages, but they could include techniques like facial recognition or other biometric scans. Even less invasive methods like requiring users to enter their birth date or ID in order to enter a site would still require widespread data collection. These techniques would have to be used for every user, not just children, resulting in increased data collection for everyone on the internet. This bill would pave the way for resources for LGBTQ plus youth or other vulnerable groups looking for support, teens looking for information on reproductive or sexual health services, including abortion access or rape crisis centers, could be prevented from accessing information that would not be suitable for 5-year-olds. Educational resources, including academic journals, news articles, or documentaries featuring graphic images or depictions of violence, could be blocked because they would not be appropriate for younger users, even if they would be useful for high school students. At a time when books with LGBTQ themes are being challenged from school libraries, including last fall, right here in Bloomington, Minnesota, and people providing healthcare to trans children are being falsely accused of quote unquote grooming, this bill could cut off another vital avenue of access to information for vulnerable youth. We agree with the need to build in greater protections for young users, but some of this bill's requirements would undermine the protections it tries to create and would also end up harming vulnerable users. Thank you.
Thank you for your time. Any questions for this testifier? All right, we have our last person, Jordan Rodell from Computer and Communications Industry Association.
Thank you, Chair Westland and members of the Legislative Commission on Data Practices for allowing me the opportunity to speak today. I'm Jordan Rodell, State Policy Manager at the Computer and Communications Industry Association. CCIA is an international not-for-profit trade association representing a broad cross-section of communications and technology firms. While we certainly support the implementation of mechanisms that ensure children's safety online, we believe Senate File 2810 may put Minnesotans at a greater risk of harm, including children whom the bill seeks to protect. I understand the proposed amendments to the bill have been released, and CCIA appreciates the change that would recognize the distinct needs and diverse experiences of children at different ages. However, we still have some concerns with that and require additional time to thoroughly assess the new language before offering any further comments. There are many concerns we would like to raise about the policies the original language of the bill would implement. First, it is imperative to prioritize establishing a comprehensive data privacy law that provides baseline protections applicable to all consumers. This law should incorporate safeguards for sensitive data, specifically addressing information commonly linked to younger users. Next, to achieve compliance by estimating the ages of users to a quote reasonable level of certainty and avoiding the proposed penalties for violations, it is likely that age estimation would amount to age verification, which would paradoxically force companies to collect a higher volume of data on children, including their geolocation, to ensure they do not reside outside of the state when confirming that they are of age to be using these services. Despite the proposed amendments to the bill, companies would remain compelled to gather a child's geolocation data as a means of demonstrating compliance. Businesses may be forced to collect personal information they don't want to collect and consumers don't want to give. Additionally, many proponents of the age-appropriate design code in the United States claim that the UK's internet is, quote, still working. However, this mischaracterizes the approach taken in the UK. The age-appropriate design code of the United Kingdom is not a law, but regulatory guidance rooted in a UN convention to which the United States does not belong. UK businesses processing personal data about UK children are not required to implement age estimations or other requirements in this bill in order to operate. Under US law, where the bill's language would be legally enforceable, covered entities would be forced to implement age verification measures to avoid potential liability, even if they do not want to direct their services to children. Lastly, the First Amendment, including the right to access information, is applicable to teens. Ambiguous restrictions on protected speech cannot be justified under the guise of, quote, protecting minor users online. As such, the AEDC that was passed in California in 2022 that would implement these vague requirements, including estimation and verification, is currently facing a legal challenge due to constitutional concerns and is currently before the Ninth Circuit Court of Appeals after the District Court of Northern California blocked the act from going into effect. We appreciate your consideration of these comments and stand ready to provide additional information. Thank you for your time.
Thank you. Any questions? All right. Senator May Quaid, we will give you the last word.
Well, thank you, Madam Chair and members. I really appreciate the conversation here today. There's a few things that were said that I really want to point your attention to. You had a lot of testifiers here today say that there is absolutely no way that tech could possibly age estimate without getting their IDs or collecting a lot more data. Yet, the Google Play Store prevents children from viewing and downloading adult-only rated apps. How could they do that if they don't age estimate? YouTube turned off autoplay for children. It also turned on break and bedtime reminders as a default setting. How could they do that if they don't already data collect to add age estimate? TikTok does not push notifications to children 13 to 15 after 9 p.m. and does not send push notifications to children ages 16 to 17 after 10 p.m. Highly specific ages, highly specific times. How could they do that if they're not already age estimating? Google made Safe Search the default browsing mode for users under 18. This is already what happens. Obviously, they can age estimate. So I really want you to understand that even though the internet may seem complex, we don't work for tech companies, right? We don't do all of that work. Well, one of us does maybe, but most of us don't work for tech companies on a day in, day out basis. All of the things that they say they couldn't possibly do, they're already doing. The reason why there is strong opposition to this bill is because it wants to get at the specific ways that tech companies use the data of children to promote profitable yet harmful things. So to be very clear, this bill makes sure that the personal data of a child is not used to materially harm their physical health, mental health, or their well-being, to connect them to a product, service, feature that could lead them to unsafe people, to prohibit dark patterns that lead or encourage children to provide personal data beyond what is needed to use that service, product, or feature. This is very basic. This is taking what we already have in the physical world and putting it into the digital world. It is allowing tech companies to continue to use the tools they already have to no longer use the data that they have on our children in harmful ways. We cannot allow tech companies to scare us into their false claims. This is not about content moderation. It's only about the use of data and making sure that the risk to children from the way that their data is used is assessed in the appropriate way from that service, product, feature. If they're not doing anything risky with the data, then there should be no problem. In countries where age-appropriate design code has been enforced, they still have the internet. Children still access the internet. Facebook, Google, Amazon, Apple, they all exist in the UK, still to this day. We have the opportunity to create meaningful difference for Minnesota's children. And that is why I'm asking for continued conversation, robust support of this bill when it gets to the legislative floor, both the House, the Senate. Thank you for a long hearing, Madam Chair and members, but it was really good discussion.
Thank you, Senator May-Quade. Appreciate it. Representative Niska, so what I would propose, I know we're bumping up against a deadline, but I would say we have a couple of options and it's up to you. We could wait and do this at our next hearing, or we can get started. And then if there's any additional testimony, we could certainly bump that over to the next hearing on the 22nd. It's really up to you. Or if people can stay for a few minutes later, we could maybe go a little past 3.
I'm personally, I'm fine either way. I would, I guess, encourage us to think about whether some of the people who came here today to testify specifically on this bill maybe could go, and I would be happy to let other people testify before I say anything about the bill.
Okay, well, let's see, we have James Dickey, Don Gemberling, and then Rich Newmeister. Are there any of those individuals who would not be able to come back to our January 22nd hearing? Okay. Well, and are you James Dickey? Would you like to just go ahead and you can testify today? And like I say, we will certainly take this up at our next hearing. I know this was a very dense and thick bill to hear today, so I would be certainly happy to provide additional time at our next hearing.
Madam Chair.
Yes.
I'm Don Gemberling and I can come back.
You can come back?
Yep.
And Mr. Newmeister is often here. I'm sure he could probably come back too. I won't speak for him, but I bet he could. So, Mr. Dickey, why don't you go ahead? Please identify yourself for the record and go ahead with your testimony.
Thank you, Chair Westland and honorable members of the commission. I'm James Dickey. I'm here to testify in support of House File 2480, and I will be brief as I can. I already have written testimony that you've received in the packet that you have. I'm not going to repeat that. I wanted to provide a bit of follow-up testimony based on some of the other testimony that has been submitted to this commission. Just as a reminder, in case you haven't seen a written testimony, I'm testifying my personal capacity here today. In January 2022, I argued the case Energy Policy Advocates versus Ellison to the Minnesota Supreme Court on behalf of the respondent in that case, Energy Policy Advocates. I do believe, as I said in my written testimony that I provided to the commission already, that the proposed amendment to the MGDPA in House File 2480 corrects the errors of the Energy Policy Advocates decision. It reestablishes the legislature's intent in enacting Section 13.65 of the statutes, and it properly balances the needs of the Attorney General's office and the public's right to know. I don't think, well, I'm just going to provide a few factual clarifications, I think, in light especially of the Attorney General's written testimony. First, while the Attorney General stated in his testimony that the office has never made any effort to conceal its retention of outside counsel for its lawsuits against energy companies, I think the commission should know a couple of additional details left out of that testimony related to the arrangement between New York University and the Attorney General's office. With respect to the arrangement between NYU and the AG, NYU pays the salaries of Special Assistant Attorneys General to use the powers of the Attorney General's office to bring lawsuits such as those currently active against the energy companies. And I have copies with me that I can leave with the commission of the appointment letters of two of these Special Assistant AGs, which clearly establish this. We were only able to, and I say we as in my client, Energy Policy Advocates, was only able to obtain copies of these appointment letters after filing a second Energy Policy Advocates lawsuit in July 2020. The first lawsuit that went to the Minnesota Supreme Court was filed in 2019. And the Attorney General's office did, to be fair, produce copies of secondment agreements indicating the existence of the NYU and AG relationship in 2019 in response to a separate data request. But the office did not produce the appointment letters that I just mentioned. Only several months after Energy Policy Advocates filed its second lawsuit were the appointment letters produced as part of negotiations between the parties in December of 2020. The office claimed at that time that although these appointment letters predated the second lawsuit, it only obtained those letters after the lawsuit was filed. And I have a copy of that letter from the Attorney General's office with me as well for anyone interested. This back and forth resulted in the production of these documents, which also preceded the Supreme Court's decision, so it's hard to say whether that same spirit of cooperation would exist in the post-Supreme Court decision era. Likewise, as part of the negotiations in that second lawsuit, the Attorney General's office produced to Energy Policy Advocates copies of a number of common interest agreements with other state attorneys general to which the Attorney General appears to refer in his testimony. In producing these documents, however, the office stated that it still believes that these documents are classified under the Data Practices Act as investigative data, which is in part subcategory 1D in section 13.65. I also have a copy of that letter with me for anyone interested. Again, this back and forth preceded the Supreme Court's decision, so it's hard to imagine that Energy Policy Advocates could have gotten them in a lawsuit filed today. These common interest agreements themselves do not contain privileged information, but rather discuss an agreement to keep future information privileged. Importantly, they also show the public the nature of the relationship between the Attorney General's office and other attorneys general related to environmental and climate change related litigation. This seems like important stuff. Second, the Attorney General claims that the Energy Policy Advocates' requests were particularly broad. And of course, this is what every government agency and every litigant facing a discovery request from an opposing party always says about requests for data. But these requests were not broad at all. Rather, they were narrowly tailored to get very specific sets of data. And sure, some privileged data could be responsive to these requests, but I don't think it's fair to call them particularly broad. And again, I have copies with me of every single one of the requests that are subject to the 2019 and 2020 lawsuits that Energy Policy Advocates filed for any interested persons. Finally, I think it's important to consider that whatever the commission or the legislature does with this bill will have repercussions that affect the Attorney General regardless of whether a Democrat or a Republican is in that office. Given how close the 2022 race was for the office, I'm sure we all recognize that who fills that office can easily change in future elections. The data that the Attorney General believes should not be produced is simply important for Minnesotans to know. It's important for Minnesotans to know that outside special interests are funding specific types of litigation using the powers of the Attorney General's office. It's important for Minnesotans to know how their Attorney General is collaborating with other state attorneys general. And consider a different hypothetical. What if a Republican were to win the Attorney General race in 2026 and then decide to make an arrangement just like the Attorney General's arrangement with NYU, but with America First Legal, the nonprofit law firm whose president is former Trump policy advisor Stephen Miller, a known immigration hawk? And then let's say that instead of funding lawsuits against energy companies, America First Legal pays the salaries of special assistant attorneys general to work with the Federal Immigration and Customs Enforcement Agency to prioritize deportation of non-citizens illegally present in Minnesota. Should the Attorney General's office be allowed to refuse to turn over data comprising the details of that relationship, or how the office is coordinating or collaborating with other state attorneys general? The effect of the Supreme Court's energy policy advocates decision may have that effect, unless corrected by House File 2480. The people of Minnesota deserve to know that kind of information. And so again, I thank the commission for its time. And again, I urge the commission to support the proposed bill.
Thank you. Any questions while we have this testifier here today? It appears not. Mr. Neumeister, we had a discussion when you were not in the office, in the room. We are kind of bumping up our deadline, and we took testimony from Mr. Dickey because he wasn't sure he could come back.
I may come back, and my impression would be just like, it'll be one of the first item followed in the next.
The very first thing we will address at our next hearing, Representative Niska, I promise, will be your bill. Of course. Thank you. And so we will do that, and that way we can make sure we give enough time to fully discuss your bill. So I thank you for your flexibility on that, and thank you for everyone's attention today. I believe then that will conclude our meeting for today. We will be meeting again on January 22nd and February 6th. And so at this time, this commission is adjourned.